Who you select as your successor trustee might be one of the most important aspects, one of the most important decisions that you ever make regarding your estate plan. You know, you can have the best documents ever. The documents can be drafted by an A-plus attorney. They can be exactly what you want. They can be consistent with your intent. But one of the problems is if you name the wrong party as your successor trustee, then your whole plan can fail because there's two aspects to a good estate plan. One aspect is that the documents, of course, and are drafted with regard to your intent, that they're well drafted, that they consider the law, they consider the tax law, they consider all of the contingencies that might happen. But you see, even if all of those things are taken care of, if you have the wrong person administering your trust, well, then everything might fail. So we want you to think very, very clearly about who your successor trustee is. Now, let's consider this. A lot of people aren't really sure what a successor trustee actually is. So that office, remember, if we have a revocable living trust, you're typically your own trustee for some period of time. But then let's say you become disabled, or upon your death, then someone else has to step in for you. So we want to consider who your successor trustee is. We want to make sure that you're making an informed decision, and that's why this office is so very important. When we're considering who your successor trustee might be, there's two major categories. One category would be independent trustees, and another category would be interested trustees. Now let's consider independent trustees first. You know, these are disinterested parties. By definition, there's someone who is not also a beneficiary of your trust. So when we're talking about an independent trustee, who are we talking about? Typically, we're talking about corporate trustees, such as banks or trust companies, or we might be talking about an attorney. Sometimes you'll name an attorney or your attorney as the trustee for following you as a successor trustee. Some individuals will name their CPA, and other individuals will name their financial planner. So these are all professionals who serve as trustees, and because typically they're not also a beneficiary of the trust, they're just the trustee, the party who's responsible for carrying out the terms of the trust. Because they're not also a beneficiary, they don't have any skin in the game, for example. It doesn't make a difference to them whether they invest for growth or they invest for income, as an example. What they're most concerned about is following your intent as provided in the trust instrument. So when we're talking about a disinterested trustee, we're talking about the corporate trustees like the banks or trust companies, the attorneys, the CPAs, the financial planners. Now let's look at each one of them more individually. Now, corporate trustees. Now, a lot of people say, I don't want a corporate trustee. I don't want a bank. I don't want a trust company dealing with my family, controlling the distributions, controlling the investments. Now, a lot of this is from some bad experiences that people had with corporate trustees. Back many, many years ago, oftentimes trusts were drafted where you would name a community bank or a personal savings bank, someone that you had, an institution where the family had a lot of contact with, and they knew the bank president, and they knew the trust officers, they knew everybody. But then that bank would be bought, maybe it'd be acquired, and then get a little larger, then it get larger, then it get larger. And suddenly the family has this trust, and maybe, you know, the original grantor of the trust may have died. So now you have this trust that's irrevocable, and you have this bank that they didn't really originally sign up for, you know, a bank they didn't originally name, but because of state law, because that bank acquired all the prior banks, they're now the trustee, and the family's saddled with 1-800 numbers, and they're saddled with people they don't know. They might even be dealing with trust officers not in the town in which they're located. So those are bad experiences people have with corporate trustees. But that can all be alleviated. And if the trust document, for example, says that a party, somebody in the family, has the ability to remove and replace a corporate trustee, then that problem can be solved. And oftentimes corporate trustees provide benefits to the trust. They're professional. They know the rules. They know investments. They know they can interact with your CPA, with your family's attorney. And again, they're impartial. So they don't have any skin in the game in the sense that they're not a beneficiary. So don't just dismiss corporate trustees because of that. Another objection to corporate trustees is the cost. the family worried about how much they charge. But when you're worried about that, what you should also consider is what you're paying now in financial management fees. A lot of people don't realize that with mutual funds, for example, you might already be paying the same amount of basis points, it's called, the same amount of percentage in fees as you would for a corporate trustee, and you don't get all of the service that a corporate trust department might offer. So don't just dismiss corporate trustees, but do think about them. Now you have attorneys. Some attorneys serve as the trustee for their clients. There are some confidentiality issues you want to look into. Look at the book that we talk about, the Selecting a Trustee book in that chapter. CPAs oftentimes will serve. One of the things that you have to be very careful about is when you're considering a financial advisor. Oftentimes they'll be enthusiastic about serving as the successor trustee until they find out that their compliance department won't allow them because of the financial regulations and the laws governing how financial planners can serve. Their own compliance department, for example, in the financial institution may require them to act as your agent but not act as your trustee. So these are all things we want to look at when we're discovering or we're thinking about who your trustee should be. Now, when you're considering disinterested trustees and dependent trustees, you may think about naming them as a co-trustee with maybe a party who is an interested trustee, such as a spouse or a child. But in any event, if they serve as a co-trustee, they can provide their expertise and their impartiality while at the same time not controlling everything that has to do with your trust. So that's one idea that you might consider when naming your successor trustee. Now, when we're talking about an interested trustee, that would be defined as somebody who is also a beneficiary of your trust. A great example of that might be your spouse. In my case, my wife, Patty, might be my successor trustee. And, we're in a first marriage and we have children of our marriage. So that's easier than, let's say, when you have blended families that might pose some additional concerns because the spouse is not the mother or the father of the children who become the remaindermen upon the surviving spouse's death, often in trust documents. So when we have a spouse serving as a trustee or as a co-trustee, that's not usually a bad idea because the spouse, they know you the best. They know what your intent is. They know the assets that might be involved. They know what accounts you might use to pay for large bills such as real estate taxes or things of that nature. So spouses are a good idea. Now, one of the dangers of a spouse, of course, is that if you were, example, or you are the party who governs the financial management of your assets. Maybe you're the one who does the trades. You might do them on Vanguard or E-Trade or Fidelity or one of those online services. Well, oftentimes people overestimate what their spouse is capable of. He or she may or may not be as familiar with those things, and you just attribute your knowledge to them. That's not always a good idea. So it's always a good idea when you're talking to your spouse if he or she is comfortable serving as trustee or to see if he or she would need some help. And you can name the help for them, or you can give them the opportunity in the trust document to name it themselves. They can name their own co-trustees. So these are some good ideas when we have a spouse. Now, when we name our children as successor trustees, of course, now oftentimes our children are interested parties, right, because they are beneficiaries of the trust. And it can be dangerous, for example, when the child is the trustee, you become disabled and your child is in charge of all of your assets. We want to make sure that your children know what you would want to do in certain circumstances, whether you'd want them to keep your same advisors, such as your financial advisor, such as your attorney, your CPA. Your trading and your risk tolerance, of course, is something that you'd want your child to know because he or she might be more risk tolerant than you. They might be less risk tolerant than you. There may be any number of concerns that you may have when your child is acting as trustee. In fact, in the Selecting a Trustee book, we delve into that in one of the chapters. And in the appendix, Appendix B, I give you some really good questions that you should ask your spouse or your children when they're named to see if they would be comfortable serving in these roles. Now let's talk about your disability. No one wants to speak of this, and in fact, this is one of the most overlooked aspects of trusts. So when you have your trust, you're acting as your own trustee, and then you have a successor trustee, and a lot of times people think, well, my successor trustee will step in at my death. Well, that's true. Your successor trustee may also step in the event of your disability. Now, your disability might be short-term. You might be in the hospital for a short period of time or a longer period of time. Or your disability may be long-term. Well, when will we have a long-term disability? Well, let's suppose that the grantor of the trust contracts dementia or Alzheimer's. That disability period might be years, between the initial onset of the disease and the eventual passing. So when you're naming your disability trustee, you have to think of these time periods of who would be willing to serve, who could carry the burden, and you have to think about not only the burden of actually conducting the trust business, which you can't underestimate. When my parents, my mother contracted leukemia and she had to go to the MD Anderson Cancer Center many years ago, and my father went out with her to take care of her. She needed a bone marrow transplant that would take months to actually go through with. And during that period, my parents asked me, the attorney who's also the CPA, to act as their trustee. And I didn't know what I was really getting into. Writing their checks, paying their bills, dealing with their financial advisor, dealing with their CPA. It became an overwhelming task. And this is my game. I'm very, very familiar with all of this, and I feel very comfortable doing it. So if your child, for example, is Susie, a school teacher in Topeka, well, is she prepared to do all this for you if you become disabled on a long-term basis? The book, Selecting a Trustee, does go into this, and I encourage you to read the chapters. And here again, you may want to select an independent or a corporate or a co-trustee to help your child if they're going to be serving as your trustee, or to help your spouse if they're going to be serving as a disability trustee for a long period of time. So now another important aspect of acting as a successor trustee and who you're selecting as your trustee will be who is going to administer your trust and who is going to administer your estate after your passing. Now, a lot of people are under the misconception that, it's pretty easy. All we do is we just get the assets together and make distribution. But that's not true. If you read the book, the Selecting a Trustee book, and I've also written another book, Legal Matters When a Loved One Dies, there are a lot of requirements that a trustee should go through before he or she makes distribution to the ultimate beneficiaries. For example, the trustee is required to value the trust assets, so we have date-of-death values. Many people's estates are not taxable because of the estate tax thresholds, but we still have to get date-of-death values for income tax purposes. And that's because in assets that are not, for example, in our IRAs or 401ks, the mutual funds and the stocks that we own, we get something called a step-up in the date-of-death value on the assets. So, for example, if I bought a stock at $1 a share and I sold it at $10 a share during my lifetime, I'm going to recognize a $9 capital gain. But if instead I die with that stock and leave it to my spouse or leave it to my children, they get a step up in basis equal to the $10 a share at the value at the day of my death. And if they were to sell it for $10 after my death, they recognize no capital gain. See, so these are issues that the successor trustee is going to have to deal with. They're going to have to deal with valuing the assets, have to talk to the accountants about whether they should sell some of the assets because of gains or losses. The prudent investor rule is imposed on the trustee, so he or she may want to liquidate some of the assets to cash during the administrative period, and we go into that in the Selecting a Trustee book. So, there's a lot of different requirements: clearing creditors, filing accountings, filing the tax returns, as we've noticed. So, when you're acting as the successor trustee, or who you're selecting as your successor trustee, will have all of these duties and all of these burdens imposed upon him or her. And again, you can name a corporate trustee or an attorney or an accountant as their co-trustee. That's always a good idea if you think that's going to be a very big burden. And keep this in mind. Whenever you've named somebody to serve as your successor trustee, and in the event of your death, and if they're one of your loved ones, if they're a spouse or if they're children, they're going to be going through a pretty severe emotional trauma. They've lost their loved one. So you have to consider what's going to be their mindset. Are they going to be clear enough to think, to make these decisions, and to work with your CPA and to work with your financial advisors and to work with your attorneys over the things that have to be done following your death? So these are some of the really important aspects of what you want to think about when you're selecting the trustee who will be administering your trust after your passing. Now, certain types of adult children should never act as their own trustee. Now, who are these adult children? Any child with a drug or alcohol or dependency problem, we're going to want to impose a third-party trustee on them, a gatekeeper trustee. Let's say you have a child who's a spendthrift, can't manage money, will go buy that Lamborghini with their inheritance that you wouldn't want them to buy. Well, that's somebody that you don't want to turn the keys over to. You want to have somebody watching over them, because this isn't to penalize them. This isn't to punish them. This is really to give them a loving, helping hand, because you probably want your inheritance that you're leaving them to be used for their retirement, because otherwise they might spend everything that they earn. Finally, we might want to consider a beneficiary who is a special needs beneficiary. If you have a beneficiary, for example, who is already receiving state benefits or federal benefits like Medicaid, you don't want to disqualify them, so we'll need something called a special needs trust built inside your trust, and that beneficiary should never serve as their own trustee. So these are all aspects that we want to consider and that we want you to consider when we're selecting your successor trustee. Let me share with you a tool that we have in this book and online that's really going to help you determine who might be the best candidate to serve as your successor trustee. We have a mindset quiz. It's on the back of the book. It's in a fold-out in the back of the book, and there's 8 different attributes that we've identified as important attributes that a successor trustee has. For each attribute, there are 4 different statements. And what we want you to do when you're selecting your successor trustee, let's say you're thinking about a spouse, or you're thinking about a child, an adult child to serve as a trustee, or even if you're thinking about an attorney or an accountant or a corporate trustee. So go through each of the 8 attributes and select the statement that most closely approximates what you believe that trustee's mindset will be, then add up the score. And what you probably want to do is have your party, the adult child, the spouse, whoever it is, have them take the test too and compare their scores. Now, if you want to see the results from the score, which is really important, go to estateprograms.com/selecting your trustee, and the test is online, the quiz is online. What you can do there is actually answer the 8 questions, selecting again the statement that's the most appropriate or the closest to the mindset of that particular individual. And then when you do that for all 8 statements and you fill in your name and email address, now we don't do anything with that. We don't sell that to anybody. It's all private. But when you fill those in, you'll get the score, and you're going to get the actual attribute, the actual mindset of that individual. So we encourage you to take the mindset quiz and have the parties, the people, the spouse, the children, whoever it is that you're considering, take that mindset quiz as well. It is a very powerful tool, and it will really help the family determine who's best to serve in these roles.